Congress of the World Conference on Constitutional Justice. Please be seated as our second discussion will be opening shortly. Ladies and gentlemen, welcome again to the 5th Congress of the World Conference on Constitutional Justice. Please be seated as our second discussion will be opening shortly. Right, ladies and gentlemen, once again, I announce you to enter the main hall of Nusa Dua Hall at BNDCC Nusa Dua Bali, as our second discussion will be opening shortly. for staying with us, ladies and gentlemen, distinguished guests. The second discussion will be begin shortly with the theme of application. The discussion will be led by His Excellency Kairat Mami, Chairman of the Constitutional Council of Kazakhstan. Without further ado, we invite you, His Excellency, to start the discussion. And I also would like to invite Mr. Knut Dur, Secretary General of the World Conference on Constitutional Justice, and His Excellency Zuhtu Arslan, President of the Constitutional Court of Turkey, His Excellency Aldis Levins, President of the Constitutional Court of the Republic of Latvia, and His Excellency Nadir El Momeni, Judge of the Constitutional Court of Morocco.
Добрый день, уважаемые.
Good afternoon, dear colleagues. Does everybody hear me well? Do we have interpretation?
Спасибо.
Once again, good afternoon, dear colleagues. For a few years, we were looking forward to this Congress. The COVID-19 pandemic made us change our plans. Now we have finally gathered together again. It is a great honor for me to welcome you and to announce the beginning of the second session of our Congress.
I would like to note with appreciation the great efforts by the Venice Commission, the Secretariat of the World Conference on Constitutional Justice, in organizing this statutory event. I would like to especially underscore the in-depth work conducted by the Indonesian Constitutional Court, headed by its president, Mr. Anwar Uslan, who has created all the necessary conditions for holding the Congress at such a high level in a short period of time. Ladies and gentlemen, I would also like to echo the sentiment that the overall theme of the Congress, constitutional justice and peace, is for all of us of a great theoretical and practical interest. Current challenges and tasks faced by constitutional review bodies necessitate a deeper study of the interrelation of principles of constitutionalism and social peace. Our session is dedicated to issues of application of constitutional provisions, dealing with different aspects of social peace and the role of constitutional review bodies in implementing them. A qualitative analysis of issues at hand was conducted through a questionnaire. As it has been said by Mrs. Tănăsescu, the previous speaker, they allow us to find appropriate solutions for existing problems. Our session will see as a key speaker the president of the Constitutional Court of Turkey, Mr. Zuhtu Aslan, who is well known by all of us. He has graduated from the Department of Political Science at Ankara University and also a doctoral program at the University of Leicester in the UK. He has been president of the Constitutional Court of Turkey since 2015. He combines practice with research, is a doctoral candidate, professor of constitutional law, and an author of many academic papers. As a discussant, this session will see Mr. Aldis Levings, the president of the Constitutional Court of Latvia. And later on, we will also see Mr. Nadir El Moumi, a judge of the Constitutional Court of Morocco. Let me remind you of the timings. The time limit for the keynote speaker is 20 minutes. For this discussant is 10 minutes. And ladies and gentlemen, and now let me give the floor to Mr. and Professor Zuhtu Aslan. The floor is yours.
Thank you, Mr. Chairman. Honorable presidents and judges of the Constitutional Courts, distinguished colleagues, ladies and gentlemen. It's a great pleasure for me to be here and to address such eminent participants of the World Congress, actually the 5th Congress of World Conference on Constitutional Justice. Actually, I remember I was also a keynote speaker at the 3rd Congress that was successfully held 8 years ago in Seoul, Korea. I am sure this 5th Congress will also be very successful and fruitful. Taking this opportunity, I would like to congratulate Chief Justice Omar Usman and his colleagues for organizing such a wonderful Congress. Distinguished participants, you all are familiar with the format of keynote speeches at the Congresses of the Wccj. The speakers are requested to reflect responses of the member courts to the questions asked beforehand about the main topic of the Congress. Therefore, today I am going to talk about the role of constitutional courts in maintaining social peace by referring to the responses of the relevant courts and councils. Let me start with a simple factual statement. We live in a diverse society. Indeed, diversity is the inescapable and permanent feature of human societies. In other words, we live in a world which is marked by such a diversity of culture, traditions, and ways of life. Irrespective of the argument whether this nature of social life is good or bad, it is a fact of our lives. So constitutions as social contracts cannot be silent against or remain indifferent to the fact of diversity. Justice requires constitutions to recognize different cultures of individuals and provide a legal and political environment to keep and maintain this social and cultural diversity. This is the only plausible way of maintaining the peaceful coexistence of individuals with their different and sometimes conflicting conceptions of good. In this sense, constitutional justice, through its function of protecting basic constitutional values, contributes significantly to the peaceful coexistence of individuals living in a given society. When we start talking about the main threats or dangers to the peaceful coexistence, the issue of power has always been on the top of the list. This may be better understood if we see that the most of the conflicts among different groups in a society is related to the power-sharing demands. History has taught us that the political power must be restricted effectively to protect rights and liberties of especially those who are not in power. At the end of this road, we have also met the smiling face of constitutional justice. To sum up kind of conceptual introduction, I would say that constitutional justice emerged in order to A, curb the excessive political power, to restrict political power, and B, maintain peaceful existence of people by protecting fundamental rights and liberties of individuals. With these two functions, constitutional courts make a great deal of contribution to appeasing social tension and sustaining social peace. Ladies and gentlemen, now I would like to touch upon some major issues brought before the constitutional courts in respect of social peace, as mentioned in the replies to the questionnaire. In general, the courts have reported that politically and socio-politically controversial or sensitive issues are always at stake. The scope of cases examined by the courts is broad and quite diverse, including post-armed conflict situations in some countries. Many countries have reported issues on political and electoral matters brought before the constitutional courts. They all agree that the decisions of the courts have in some way appeased the situations in their respective countries. It is also interesting to note that in some countries, the constitutional courts have acted as a kind of justice of constitutional peace in different social conflict areas, such as linguistic cleavages in the same country, divide between employers and employees, or national minority issues. In most of these cases, the courts are required to keep an appropriate balance between different constitutional principles. In fact, this is the central task of confronting constitutional courts in heavily diverse democracies today. I want to begin with the decision of the Supreme Court of Canada on the controversial issue of Quebec's secession. The court based its decision on a complicated constitutional architecture with the pillars of written and unwritten constitutional principles. The Canadian Supreme Court emphasized the mutually reinforcing nature of the principles of constitutionalism and rule of law on the one hand, and the principle of democracy on the other. Then it reached the conclusion that the legislature and government of Quebec had no right to unilaterally secede from Canada, but they have the right to initiate a constitutional amendment in this way. To give some other examples, in North Macedonia, the Constitutional Court resolved the ethnic tensions linked to the display of Albanian and Turkish flags in addition to the state flag. Eventually, the parliament passed a law to solve this problem of displaying of flags of different ethnic groups. Moreover, the Belgian Constitutional Court decided that the difference of treatment and categorization as manual or intellectual between workers and employees were unconstitutional. On this subject, the court has settled numerous disputes and thus continued to safeguard social peace. Ladies and gentlemen, the reports of the constitutional courts have revealed that social conflicts based on religious matters were among the most formidable challenges before our constitutional courts. In cases involving the use of religious symbols like headscarf in public sphere, some constitutional courts delivered judgments having an effect on the social tension in different ways. For instance, the Federal Constitutional Court of Germany had the opportunity to examine cases regarding the religious freedom of Muslim teachers to wear headscarves while teaching at school. Upon the constitutional complaints, the Federal Constitutional Court held that imposing a blanket headscarf ban was unconstitutional. The court pointed out that there was no sufficiently precise legal basis, statutory basis, justifying the restriction imposed on teachers wearing a headscarf at school and during classes. On the contrary, in 2020, the German Constitutional Court found the ban on female legal trainees wearing headscarves in the courtroom compatible with the basic law. This time, the court concluded that the legislature's decision to establish a duty of neutral conduct with respect to ideological and religious matters for legal trainees must be respected. In France, the ban on headscarf and other religious symbols have always been the subject of heated debate from the very beginning. Most recently, the Court of Cassation of France upheld the ban on barristers wearing headscarf and other religious symbols in courtrooms. When it comes to Turkey, a Muslim majority country, intense discussions had taken place on the constitutionality of headscarf ban in universities and also in public offices. In 2008, the Turkish Constitutional Court annulled a constitutional amendment which Parliament had enacted to abolish the headscarf prohibition in universities. The court ruled that the amendments infringed the constitutional principle of secularism or laicism. With the introduction of individual application system in 2012, the Constitutional Court of Turkey has shifted its direction to apply constitutional principles in favor of human rights rather than state ideology. The Turkish court has adopted a rights-based approach and started to interpret secularism as a constitutional principle in harmony with fundamental rights and democratic society, and therefore it contributed a lot to social peace. In this regard, let me briefly mention the 2014 decision on the headscarf issue, which is a leading judgment of the Turkish Constitutional Court. The case concerned a lawyer's exclusion from a courtroom for her wearing a headscarf. The trial judge decided that the lawyer's presence in the hearing with her headscarf was contrary to the principle of secularism under the case of the Constitutional Court of Turkey as well as the European Court of Human Rights. The Turkish Constitutional Court dealt with this case by ruling that intervention in the applicant's freedom of religion didn't meet the constitutional requirement of lawfulness. In other words, the restrictions must be prescribed by law, and the court found no law prohibiting wearing headscarf in universities as well as in the courtrooms. And the court reached the conclusion that the applicant's freedom of religion and right to equality were violated. Finally, I must note that the European Court of Human Rights has granted a wide margin of appreciation to the contracting states regarding the headscarf ban. The Strasbourg Court found the bans in France and Turkey compatible with the European Convention on Human Rights. on various grounds, such as protection of secularism, gender equality, and rights and freedoms of others, formulated as living together. On the other hand, the Strasbourg court found that the exclusion of a Muslim woman wearing Islamic headscarf from the courtroom was not justified in a democratic society. And the court ruled that the applicant was an ordinary citizen and her behavior, namely entering the courtroom with a headscarf, was not disrespectful and posed or was likely to pose no threat to the proper conduct of hearing. And following this judgment of the Strasbourg court, the respondent state took a positive step to remove the ban on wearing a headscarf in courtrooms and accordingly amended the law that was the source of violation. Distinguished colleagues, ladies and gentlemen, I think we can draw four main conclusions from the summary of replies, and I've just mentioned only a few of them. First of all, there is a universal consensus on the necessity of pluralism and diversity. As indicated in the case law of the European Court of Human Rights, a healthy democratic society needs to tolerate and sustain pluralism and diversity in order to protect rights and liberties of individuals. Secondly, the decisions and judgments of constitutional courts have had a calming effect on social tensions. They have played a significant role in mitigating and resolving social conflicts, as well as in maintaining and sustaining social peace. Thirdly, this role of constitutional courts is limited because not only most of the constitutional cases involve politically sensitive and extra-constitutional problems, but also the courts cannot act on their own initiatives. Finally, the ultimate success of maintaining social peace lies in the belief that just and rights-based decisions of the courts can resolve deeply sensitive problems of social conflict. In this regard, public trust in judiciary in general and constitutional courts in particular will help them to appease social tensions and sustain peace in society. It must also be noted that maintaining peaceful coexistence requires a strong mindset. Indeed, we need to tolerate and recognize the ontological status of the others who are different from us. We must embrace the others as human beings without forcing them to resemble us. Let me conclude my speech by citing some words of Saidi's poem Children of Adam, written nearly 1,000 years ago. Saadi Shirazi says that if you have no sympathy for the sufferings of others, deserve not the name human being. In order to ensure social peace, to go beyond a mere rhetoric, we must not only inscribe Saadi's expressions on the entrance of the United Nations buildings, but also wholeheartedly adopt and realize them. Thank you very much for your attention. Terima kasih.
Спасибо, господин Арслан.
Thank you, Mr. Arslan, for a very interesting and excellent speech. Really, the Constitution as a social contract bears in mind various interests and requirements. Once again, I thank you, Mr. Professor. And now I offer the word to the chair of the Constitutional Court of Latvia, Mr. Aldis Lavinš. The president graduated from the Latvian Institute. He has a degree in Master of Law, and he is the author of many scientific publications. Mr. Chairman, please, you have the floor.
Mr. Chairman,
distinguished colleagues, I am truly honored to address all of you in this immensely important forum, which I believe enhance judicial dialogue across the globe, and it really helps us to understand each other better. So thank you, Mr. President of the Constitutional Court of the Republic of Turkey, for your analysis of the role of constitutional courts in maintaining social peace. As a discussant of this session, I am responsible for fruitful discussions, and that's why I have prepared 3 short reflections, 2 questions to my esteemed keynote speaker, and maybe 1 question to each of you. So, my first aspect. Honorable keynote speaker emphasized that pluralism and diversity are needed and essential for a democratic society. Speaking about this aspect, I believe that starting point must be the concept that each person is unique, and society, which is based on the idea of freedom, is the most appropriate environment to realize ourselves. If we can realize our personalities in many different ways, we can contribute to the development of our countries. However, I can share the concerns of the keynote speakers that social diversity can affect social peace. Dealing with cases where some social conflicts are at stake, constitutional courts, in my opinion, have to bear in mind that, on the one hand, freedom of individuals must be respected, but on the other hand, national constitutional identity draws an ultimate line for proper balance. That means a person can exercise freedoms only within so-called the unchangeable core of the Constitution, and democracy should not function only in a way that this person or some group of society accepts democracy when its preferred opinion prevails. Individual freedoms, mentioned before, could be protected and balanced by the Constitutional Court dealing with the applications submitted by any individual person. Dear colleagues, since an individual type of application, and I mean constitutional complaint, is an effective instrument to protect human rights, constitutional courts actually have become the key players in ensuring so-called unity in diversity for the whole society. So, and that's why I would like to ask a question to my honorable colleague, keynote speaker. What could be the reasons why many legal systems across the world still don't embrace the idea to introduce individual complaints? Why so many countries don't use in their jurisdiction so effective instrument through which constitutional court can play significant role maintaining peace and social justice? My second aspect, I would like to touch upon question, what is the legal base for the constitutional courts to ensure social peace? Well, in essence, the members of the conference were asked whether the existence of precise regulatory framework for peace and reconciliation is the precondition for the courts to ensure it. Colleagues, in my opinion, the question of a precise regulatory framework does not play any significant role. It's because the necessity to ensure social peace derives from the values that are enshrined in our constitutions. In spite of the fact that regulation about social peace does not exist expressis verbis, such values as democracy, sustainability, human dignity, and protection of fundamental rights are those fundamental pillars that should guarantee peace and reconciliation in every situation. By interpreting the catalogue of fundamental rights in conjunction, a fair balance between competing interests could be reached. At this point, I would like to highlight in particular the conclusions made by the keynote speaker. Even if the majority of constitutional courts have not referred to the terms social peace and reconciliation, they have facilitated peaceful societal coexistence by ensuring and promoting such constitutional principles as separation of powers, rule of law, democracy, and human rights. Dear colleagues, at the same time, the constitutional courts should bear in mind that values enshrined in the Constitution as a legal basis, in my opinion, are rather broad and should be applied in a manner that ensures social peace, not dividing society. In order to promote discussion, I would like to ask my esteemed colleague again. Well, we can imagine a situation where politicians, due to lack of consensus, choose not to address a socially and ethically ambiguous issue. And just, for example, I could mention the question of euthanasia. So, should the courts rule on the issue which are debated in Parliament at the same time? If yes, how courts could avoid polarization and conflicts in society, as well as constitutional crises related to disputes over the limits of judicial competence? Dear colleagues, now I turn to my third and final point. Please take a look at the symbol of our Congress. It is a dove of peace and map of our beloved world. Right at the heart of our symbol is Ukraine, where a brutal war is taking place right now. Torture and murder of Ukrainian civilians are Russia's routine in this war. Since I have to talk about the application to the Constitutional Court, but not about war, anyway, I would like to ask this prominent audience, what kind of application the Constitutional Court of Russia is dealing with? The answer was given by the court itself, actually. Just for your attention, just 3 days ago, this court, violating international law, endorsed the annexation of part of Ukraine's territory. In doing that, this court has turned into a political institution for legitimizing the ambitions of an autocratic regime. And it does not truly care about the social peace, neither in Ukraine nor in its own country. Such a court, dear colleagues, is no longer a court in a sense of Article 1 of the Statutes of the World Conference on Constitutional Justice. The aim of this article, I mean Article 1 of our statutes, is to unite all world's constitutional courts which are truly committed to such common values as rule of law, democracy, human rights, and human dignity. If my dear colleagues from other continents truly believe that the Russian Constitutional Court still complies with the Article 1 of our statutes, then I would like to pose this question I promised. Dear colleagues, what else should happen in the world that could serve as a real ground for excluding an aggressor state's constitutional court from the world's constitutional court's family? Thank you.
Спасибо, господин Лавинч.
Thank you, Mr. Levinch. Your expressions cleared up a lot of aspects of the keynote speaker. And so, dear colleagues, before I open this discussion, the speakers touched on important questions. They talked about the agreement of certain interests, the reconciliation of certain interests in the justice, the role of constitutional courts in the human rights, and the refusal to monopolize state power. So, dear colleagues, I ask you all to introduce yourself, and please, in your speeches, please limit yourself to 3 minutes. And the first floor, I would try to offer to Professor Zuhtu Arslan to answer the questions which Lavinch posed. Please.
Thank you, Mr. Chairman. Thank you, the Honorable President of the Constitutional Court of Latvia, for this very complicated and very sensitive questions. I will do my best to answer your first two questions, and the third one was not a kind of question, it was a comment. So I will try to answer your first and second questions related to the means of maintaining social peace, that is the constitutional complaint, the adoption of constitutional complaint, and the reason why not most of the constitutional courts so far didn't adopt this mechanism of individual application or constitutional complaint. And the second question was about the legal base of the mandate for constitutional courts to deal with the issue of social peace and to ensure the social peace and to appease social tensions. So let me start with the issue of constitutional complaint. Actually, in Turkey, not Turkey, but Turkey, we have just changed the name of, actually in English, the name of our country. Now it is Turkey, we call it. It is also accepted at the universal level. So I will do my best to pronounce Turkey rather than Turkey. In Turkey, we have been exercising the system of constitutional complaint, or what we call individual application, for 10 years. Recently, we celebrated the 10th anniversary of introducing the system of individual application or constitutional complaint. I think the reason why so many constitutional courts have not adopted so far the system of individual applications lies in the fact that it brings about too many workload, too many applications. It is a formidable challenge for all of us as the constitutional course if you deal with individual applications. I can only say that currently we have over 120,000 individual applications pending before the Constitutional Court of Turkey. So that's a great challenge. That's a formidable challenge for us to deal with. But on the other hand, I agree with my colleague that constitutional complaint system is one of the most effective instruments for the constitutional courts to protect rights and liberties of individuals. So I strongly urge many other constitutional courts to adopt this system, but of course it requires a constitutional or legal amendment in respective countries. But it is, at the end of the day, very effective way of protecting rights and liberties, and in turn ensuring the social peace, maintaining social peace, sustaining the social peace and appeasing social tensions. Because you can see many aspects of the problem of social tension or conflict through the individual complaints. Every individual in your country has the right to appeal directly to the Constitutional Court in terms of the allegation of violation of his or her certain constitutional rights. So it's an effective way of protecting rights and liberties. And I hope in the future more or more countries and constitutional courts will deal with this effective way of protecting rights and liberties. I agree again with the President of Constitutional Court of Latvia that we don't need a special legal base in order to deal with the problems arising from social conflicts or social tensions, because our courts are established in order to protect the principle of rule of law, separation of powers, and especially human rights, the rights enshrined in the Constitution. And this requirement also leads us to the mandate of ensuring social peace. So we don't need a special provision in the Constitution or in any legal text to mandate us to work towards ensuring social peace. I think that will be enough for the questions. Thank you.
Спасибо, господин председатель.
Thank you, Mr. Chairman. Please, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Allow me. I am the part of the Legal Commission of the Parliament to convey the highest appreciation to this forum. What's happening? No interpretation yet. Can you hear me? Is it working?
We can hear you. I should apologize for the technical difficulties that we had in the morning, but they have been fixed now. To tell you that was because we have two companies working, one working for the World Conference, one working for the Constitutional Court of Indonesia. These problems are fixed. We hear you. It only takes some time until interpretation goes from first from one language and it's further translated. So I think we hear you now. Yours is not.
Testing English channel. 1, 2, 3. Can you hear me?
Please.
Is it working now? Greetings and may peace be upon you. I'm Abu Bakar Al-Habsi. I'm a parliamentarian from the Indonesian Parliament, part of the Legal Commission. I would like to express my highest appreciation to this forum and also to pose a question to participate in the discussion. I really appreciate the Indonesian Constitutional Court for having organized this very esteemed scientific event where different constitutional justices can take part in a very quality level discussion. I would like to know your opinion about limitations to constitutional reviews in Indonesia. The Indonesian Constitutional Court, they often decide that some issues are not constitutional issues and instead give the opportunity to the legislators to resolve these issues, saying that they have no authority. And this is what they call an open legal policy. However, this is like a blank check given to the legislators. Or would it be possible for constitutional courts to provide some guidelines? So even though some issues are legislative issues, the Constitutional Court can assess whether some issues have gone beyond certain parameters. For example, the Constitutional Court has reviewed the provisions on the parliamentary threshold for over 30 times. They have received so many petitions. Many part of the public considered that threshold of 25% is unconstitutional. The Constitutional Court has always evaded that question, saying that that is not a constitutional question. Again, thank you for the opportunity given, and to continue to what has been stated by the presenters, I would like to ask about the legal strength and foundation of ratio decidendi regarding, for example, we as legislators, should we follow their reasoning or their final decisions only? These are my questions. Thank you.
Does anybody want to answer this question? Please, the floor is yours, Dr. Zuktu.
Thank you for this contribution. Well, I don't know the situation in Indonesia concerning the relationship between legislature and constitutional court. But in my country, in Turkey, we have also been discussing these issues in the area of constitutionality of acts passed by the parliament. Yeah, we have the doctrine of political questions, or as you mentioned, constitutional questions. We rather call them as political questions, which are beyond the scope of the constitutionality review. But Turkish constitution clearly lay down the basic powers of the Constitutional Court of Turkey. There are certain provisions in the constitution that deal with the scope of the constitutionality review. I already mentioned in my speech that in 2008, the Constitutional Court reviewed the constitutionality of the constitutional amendment itself, and it annulled the constitutional amendment. And this caused a very difficult discussion in Turkey. And now the question whether the Constitutional Court has the power to review the constitutionality of constitutional provisions themselves. The court said that yes, it had the power to review and annul the constitutional provision, and it did in reality. But I have some doubt about such judicial activism, whether we should adopt such judicial activism towards our powers, or we should restrain ourselves from exercising unconstitutional powers. I think we must stand in the middle of judicial activism and judicial restraint. The courts, the constitutional courts are given, they are mandated by the Constitution, and they shouldn't violate the Constitution itself, because we are supposed to protect the Constitution against any power, whether it is legislative or executive or other social powers. So we must protect and abide by the Constitution first. Related to your second question, whether the legislature should take care of the reasoning of the Constitutional Court or the final decision of the court. This is also another subject of discussion in Turkey. And this is a very heated debate. There is a very heated debate in Turkey whether the reasonings of the court is also binding on the legislature or other courts, in fact. We say that yes, the final judgment of the Constitutional Court is binding. You have to abide by the final decision of the court. But you have to, as the parliament or as any constitution, any court, you have to take care of the reasons themselves. Otherwise, you cannot sometimes understand what the final wording of the any court says about the decision. So you have to take the whole of the decision together with the reasons any court has given, and you have to evaluate the decision as a whole. But of course, in our case, we always say that yes, our final judgment is binding, but you must also take care of the reasons themselves in order to avoid any unconstitutional act in the future. Thank you very much.
Спасибо.
I thank you. Indonesia, please, the floor is yours. If you would like to answer, please, the floor is yours.
On those two questions from the perspective of Latvian legal system. Of course, this question about relationship of constitutional court and legislator are really sensitive. But in spite of that, according our methodology, how constitutional court realize review of constitutionality, I have to underline that one of aspects is what we are checking is whether state has fulfilled its positive obligations. And then, if, for instance, state does not react to the demands of society that certain legal relationship should be regulated by the normative act, then it would be on the desk, it could be on the desk of the Constitutional Court of Latvia, and we can rule on this issue whether state has fulfilled, as I said, its positive obligation. And in doing this, we try to bear in mind context in Europe. For instance, situation is a little bit easier if we do have jurisprudence of the court on human rights, and then it really helps us to find a proper balance in such a sensitive situation. This is one short answer, and to the second question, I would say that according law which regulates procedure at the Constitutional Court, our rulings, of course, are binding, and it regards not just only to the operative parts of our ruling, but as well to the reasoning parts. So it means the interpretation given by the Constitutional Court binds even legislator. Thank you.
Thank you. Indonesia, please. Your questions.
Thank you, Mr. Chairman. I am Justice Eni Nurbaningsih from Indonesia. His Excellency Professor Aslan, regarding your presentation, I would like to get more explanation in your Constitutional Court experiences. As far as I know, in the pluralistic countries and developing countries, there are some challenges to enforceability to law. How far the decision of the Constitutional Court could be bound by everyone to be done effectively erga omnes principles. And the second one, I would like to get more explanation again. You mentioned that you mentioned that a constitutional individual. You said that we don't need amendment of the constitution if we want to add the authority of the Constitutional Court. The problem is if the one country recognize the hierarchy of law and the authority of the Constitutional Court based on the Constitution, how far? How come we can get more or get additional authority of the Constitutional Court? Thank you very much.
Thank you, Mr. Zuhtu. The floor is yours.
Thank you, Mrs. Justice of the Indonesian Constitutional Court. Actually, these two questions are very hard questions. Let me begin with the first one. Yeah, we also discuss the erga omnes effect of the decisions of the Constitutional Court of Turkey, especially after the adoption of the individual application system. We talked about the subjective and objective effect of violation judgments of the Constitutional Court. As we all know, subjective effect and binding force of the Constitutional Courts or any court is much more easier to deal with. When specifically find a violation in a certain concrete case, the requirements of the judgment are very clear. But when it comes to the question of objective effect of violation judgments, it is much more complicated. And we argue in Turkey that the decisions, violation judgments of the Turkish Constitutional Court must be observed by everyone living in the country. I mean, you don't have to apply an individual application, you don't have to launch an individual application in order to benefit from the violation judgments delivered before your application. So, objective effect of the judgments are very important in order to realize the supremacy of the Constitution, because in every case, whether it is the constitutionality review case or individual application case, we interpret the constitutional provision and we reach a conclusion whether it is contrary to the Constitution or not. And when we find a contrary provision or act of executive, and when we declare that this is unconstitutional, and everybody must obey this decision. There is no doubt about it. And as to your second question, I didn't say that we don't need constitutional change. We sometimes need constitutional change because we are living in a dynamic society, and the text, including constitutions, are static materials. They are static. They have to follow the changes of society. So we need to change sometimes constitution, but in order to ensure the hierarchy of norms, we don't need to go beyond our power. The powers of the constitutional courts are enshrined, prescribed in the Constitution itself. If you need more power, you have to change the Constitution. If your Constitution doesn't give your court the power to review the constitutionality of the constitutional amendments, you don't have to produce it through your case law. Thank you very much.
Уважаемые коллеги, я извиняюсь.
Dear colleagues, I apologize for rushing this session. It is time for us to sum up. I believe that we had a fruitful discussion. We heard interesting presentations and comments. I hope that this session helped us conduct a comprehensive discussion of these issues, and together we managed to find solution. I thank all participants for their active participation. Special thanks to our speakers and discussants. I wish success to our speakers, Mr. Nadir El Mumni, who will speak tomorrow, and he will talk on the outcome of our work at the final session of the Congress. I would like to say thanks and congratulations to the Constitutional Court of Indonesia for the warm welcome and the excellent organization of the Congress. I declare this session closed. I thank you, and I wish all of you success and a pleasant stay in Bali. Thank you.
Right, thank you. His Excellency Khairat Mami, Chairman of the Constitutional Council of Kazakhstan, and other excellencies. Right, ladies and gentlemen, distinguished guests, let us move to the third discussion on today's event with the theme of limitation of the role of constitutional courts in maintaining peace. The discussion will be led by His Excellency Adel Omar Sharif, Deputy Chief Justice of the Supreme Constitutional Court of Egypt. Without further ado, we invite you, His Excellency, to start the discussion. I would like also to invite His Excellency Emil Oskonbay, Chairman of the Constitutional Court of Kyrgyzstan, Her Excellency Laurinda Prazeres Monteiro Cardoso, President of the Constitutional Court of Angola, and His Excellency Candido Conde Pompido Toron, Judge of the Constitutional Court of Spain.
In the name of God All-Merciful, peace be upon His Prophet. Good afternoon.
I'm the First Deputy Chief Justice of the Supreme Constitutional Court of Egypt, joined today with a delegation from my court, Justice Abdulaziz Salman, Justice Tariq Abdul Alim, and Justice Tariq Chibr, all Vice President of the Supreme Constitutional Court of Egypt. At the outset, we just like to extend our deep condolences to the Indonesian people for the grave and devastating incident that took place earlier this month out of the soccer games. So we extend really our deep condolences for all of you. First and foremost, let me begin by extending my gratitude to the organizer of the conference, the Honorable Chief Justice Anwar Osman, President of the Constitutional Court of Indonesia, and the Secretary General of Venice Commission, the World Conference, and the Honorary President of Venice Commission, our good friend Wccj, for continuing working for us as an international constitutional judicial community and giving us such opportunities to get together continuously to share issues of common concern that's really needed to improve the quality of our performance in our respective jurisdictions. So I really adapted for all of them, for all the efforts they have exerted to allow us to be in this platform here today. I also would like to thank all of you who are here today, our colleagues, president and members of constitutional courts worldwide, and all delegations that have joined us this afternoon. I also extend my gratitude and appreciation to the rest of the guests who are here today. Ladies and gentlemen, I still have to elaborate my gratitude to the Secretariat of the Venice, of the World Conference, how do you call it? World Judicial? World Conference on Constitutional Justice. I'm so sorry because my just, for picking up the topic of this conference in particular, for the novelty of the theme, even though it might has seemed to be a little vague to some of us within some jurisdiction as reflected in the response to the reply, but when you look into the concept paper, you would find that it has really elaborated extensively to give us really an indication of peace and what is meant by peace, and given us a clear definition that is relevant to social peace, even though peace is not only social, it has to be understood within other perspectives from a constitutional point of view. I'm not here to elaborate on that. I think the main speakers and the discussants have the role to do this. Nonetheless, I just given a few opening remarks to this important topic that we are about to address. In addition to my gratitude to the General Secretariat of the conference, I also would like to extend my gratitude to the AACC and the CCJA for the initiative they have taken yesterday and this new model of cooperation that they have shown us through hard work. I congratulate them for developing the memorandum of understanding that they have had already and to continue working together. And I believe this is a great model for all of us to benefit from. And I wish them all the best. I congratulate my friends and colleagues in Algeria and all those parties involved in this process. I also extend my gratitude to all of you who have participated seriously in this process. The topic of this session, as you have seen, has to do with limitation of the role of constitutional courts in maintaining peace. And there has been about 4 questions raised within the questionnaires and requiring our courts to respond, and we have seen our courts elaborating on all of them with different views. And as I indicated earlier, the definition of peace has been a little bit problematic for some of them, which led to diverse points of view in some contexts. In addition, the issue of limitation on the court's power to handle constitutional cases also is a critical one and has to be understood in terms of limitation that does not necessarily or should not necessarily be taken in a negative perspective. Apparently, we do, as constitutional justices, impose limitation ourselves. We do that simply because we live in a state of law, and each institution within the state should be abided by the law. Abiding by the law would require you to have a regulatory framework to perform your duties within this framework. And if we have to separate amongst the three powers of government and has each one of them respecting the law, including the judiciary, including the constitutional court, then we would understand that the existence of some limitation in your power in exercising judicial review would be acceptable. So we shouldn't ever take this for granted as a negative perspective in our performance. In addition, the other topic that is also need to be elaborated on is the finality of our decisions and irrevocability, non-availability. All these major issues has to be looked at more seriously, and we have seen some responses, and I leave it to the discussion and the main speaker to elaborate on that. And finally, the image of the court and the media and before the people's eyes. All these are serious issues, as I have indicated, and I would expect to hear a lot from our main speaker. Luckily, we do have a very distinct panel here today, and our panel composed of the Honorable Chairman Emil Oksunoviv, the President of the Constitutional Council, Kyrgyz Republic. His Honor has a long-serving judicial career since his graduation from the law school back in 1986, moving mainly within the public prosecution office, then arriving at the Constitutional Court, first as a justice in 2011, then as the vice president in 2019, and finally president of the court since 2022. He's the judge of highest qualification class, honored lawyer of the Kyrgyz Republic, and has a very distinct judicial career, and we would be honored to hear from them in a while. We also have President the Honorable President Leonardo Cardozo, the Chief Justice or the President of the Constitutional Court of Angola. She's known to be the most attractive Chief Justice in the world, I have to admit that. Though young, she has also a very distinct judicial career. She has a very distinct judicial career, moving from private practice at the beginning to public service until she became the State Secretary for Territory Administration, and finally as a Chief Justice or President of the Constitutional Court in since 2021. Also, we have our rapporteur, who is unfortunately couldn't join us physically today, but he's joining us online already, Justice Candido Kondo Bombido Torton, Justice of the Constitutional Court of Spain. I think all of you know him, the exceptional judicial figures. He has been having a very distinct judicial career since his graduation from law school back in 1973. Has been serving with the Public Prosecution Service and even became the State Attorney General from 2004 to 2011. And in addition to his involvement in judicial work at the national level, he's always been a very active member at the international judicial community, wherein he was the president of the Ibero-American Association for a Public Prosecutor from 2007 to 2011, and president of the network of the Attorneys General of the Supreme Court of the European Union in 2009 and 2010. Justice Candido arrived at the Constitutional Court of Spain in 2017 and is still serving there. Apparently, his owner, Justice Candido, as I said, is unable to join us, but he asked us to display a short video from him sending a note to you. So we start with this very short video. Afterward, we will have our keynote speaker, then our discussion. Thank you.
Querido presidente del Tribunal Constitucional de Indonesia, querido secretario general de la Conferencia Mundial, dear chairman of the Constitutional Meeting, distinguished presidents and magistrates of the constitutional courts and constitutional courts that participate at this event, dear colleagues, it is indeed a great pleasure for me and an honor have an opportunity to address such a distinguished group of judicial experts, although I'm talking to you from Madrid and in a different way, and the interpreters do not have a speech. Let me say on behalf of the constitutional lawyers of Canada, transmit our warm greetings. I would wish to thank especially the chairman of the Indonesian Constitutional Court, as well as the Secretary General of the Wccj, Mr. Noor. I thank them for their kindness and for the facilities provided so as to be able to transmit this to you before we reach the keynote speaker of this 5th conference. At the same time, I'm greeting you from a distance and greet my colleagues of the rostrum here, namely Omar Sharif, Deputy Chief Supreme Court of Egypt, Emil Konstanov of Kyrgyzstan, and Linda Prazeres of the Court of Angola. I would like to thank all of the speakers at this conference. You have made excellent efforts both in the organization as well as in the presentation of speeches to have such an excellent forum. We support and hope and support the main object of this conference, which of course is to promote through legal dialogue constitutional justice as a key element for the strengthening of democracy, the promotion of human rights, and the strengthening of the state of law. This is no doubt a very noble aim, which is that to increase and improve the practice of congressional cooperation by the implementation of our constitutions, which is of course very necessary in the very hard times that we are facing now. This is why, distinguished delegates, I would like to view this beautiful convention center where you are now in the very famous island of Bali, so that you can continue together with this gathering, which started in 2009 and which has continued in our meetings of Rio de Janeiro, in Seoul, and now here. Unfortunately, I have not been able to go to Bali to be there with you, so I thank you for the preparations made. In the next few days, there will be a renewal of our constitutional court, which implies several changes, which means that all of those involved in the constitutional court in our country must remain in our country. So this is why I congratulate, at least via this video, at this Congress, which deals precisely with constitutional justice and peace. This is very important in the case of constitutional peace, electoral peace, and in the search for reconciliation after internal conflict. The aim of law is precisely that, to achieve justice and peace, and to make them as synonyms of the human development in the benefit of the human development. The whole history of humanity is precisely that of walking towards the struggle for the implementation of law for the structure of right. So therefore, I would congratulate you in this session on limitation of the role of constitutional courts in maintaining power. I think this is a very pertinent subject because it helps us to deal with these subjects which we must face. Indeed, the limitations that constitutional courts might face when they try to achieve peace can be of a formal nature or of a process nature, but they can in fact contribute to a situation of peace that can lead to the rule of law, which can lead to peace and for a further development of human rights and constitutional courts. Therefore, I only wish to say that it is for me a privilege to be able to be the rapporteur for this session, to try to concentrate and summarize the various discussions that we will be having. Thank you, dear friends from out Madrid. I send you my warmest regards on behalf of the Constitutional Court of Spain, the Court of Spain. I thank all of the present here at this forum, which is meeting right now. Thank you very much.
So now we turn the course to His Excellency, the Honorable Chairman Emil Oscar, the President of the Constitutional Court, Constitution Council, Republic of Kyrgyzstan Republic. So, Your Excellency has the floor, and you have 20 minutes to read your paper.
Thank you, Chair. Your Excellency, President of the Indonesian Constitutional Court, Anwar Uslan, dear colleagues, ladies and gentlemen, I am very pleased to greet the participants of the 5th Congress of the World Conference on Constitutional Justice and would like to express my gratitude to the previous speakers for the very informative presentations. I am the keynote speaker of Session C on the topic of limitations of the role of constitutional courts in maintaining peace. We should not underestimate the role of constitutional courts in upkeeping the social peace. Therefore, understanding the essence of the existing objective limitations of the role of constitutional courts is very important. In this session, we'll look into the general trends in the functioning of constitutional courts in terms of their relations with other state bodies, the attitude of the mass media towards the constitutional control bodies, as well as the importance of applications and appeals as an imminent condition for initiating constitutional proceedings. Of course, the important role of the Constitutional Court in establishing peace in any country in the context of the country's sustainable development and political social stability is difficult to overestimate, since the decisions of the constitutional control body improve the legislation relating to all areas of public relations. Through their legal positions, the body of constitutional control actively contribute to the constitutionalizations of the lawmaking process, guiding legislators towards the implementation of constitutional norms. Based on this, the main institutions designed to detect and correct violations of fundamental principles of legal regulations is the Constitutional Court. Let's look at the questions asked and look at the organization of constitutional courts these days. In the beginning, let's try to understand what are the limitations of courts in contributing to social peace. Today, it's extremely difficult to imagine a democratic state without a body of constitutional control, functioning to protect the constitution, to ensure its supremacy, ensure the principle of separation of powers, and protect human rights and freedoms. At the same time, informatization, technological development lead to the emergence of new social relations, which in turn may contain some challenges to constitutionally protected values. Based on the replies we received on the questionnaire, we see that constitutional courts cannot initiate institutional proceedings on their own initiative. Many countries believe that it should not, so courts should not initiate constitutional proceedings on their own initiative. So submission of an application is still a prerequisite of initiating any constitutional court proceedings. And here I would like to note a very important fact. Our distinguished president said that this question should not be viewed only in a negative context. I'm talking about limitations. It's not only a negative sense. So I believe that constitutional review bodies should not have the right to initiate constitutional review proceedings because it may lead to other negative consequences. I believe that the solution lies in determination, the remit, or rather in determining what applicants may apply for constitutional review, so that the applications are made and the constitutional review proceedings can be initiated. At the same time, if we look at some examples, for example, in Serbia, the Constitutional Court has the right to initiate the assessment of constitutionality if such decision is taken by 2/3 of all judges. But so far, the Constitutional Court of Serbia has been restrained in exercising this power. I believe that the judges of Serbian Constitutional Court has considered the same aspects as I just mentioned. At the same time, in Côte d'Ivoire, the Constitutional Court can consider applications only referred if they are referred by competent authorities. In Mauritania, only the President of the Republic, Prime Minister, or the Chairman of the National Assembly are vested with the right to apply to the Constitutional Court. And the decision must be made by 1/3 of the deputies of the MPs. And this brings us back to the idea which I have just mentioned that the pool of subjects that may apply for proceedings should be set out, and because there can always be found a competent person, so to speak, that may apply to the Constitutional Court. Also, I would like to note that to a small extent, it's an indispensable condition for filing an application, the fact that constitutional courts carry out constitutional review only by considering applications. As a rule, citizens of any country striving for social and legal equality exercise their constitutional rights by applying to constitutional courts for protecting of their rights. And with the exception of special procedures regarding to written court hearings, principles of competitiveness and equality of the parties is upheld. On one hand, the applicant, having applied to the Constitutional Court with a request, raises the issue of inconsistency of a certain provision of the law, and the body that made such act defends their position on the compliance. And in the process of hearing the case, the Constitutional Court, based on the examination of arguments of both parties, makes a ruling on constitutionality of such norms. And such ruling allow constitutional courts to perform the function of improving shortcomings of legislation. And here I would like to specifically note the practice of existing in Kyrgyzstan, my country.
In adopting the Constitution of 2010, into the Constitution, a norm was introduced which sounds like this, that each person has the right to approach the Constitutional Court if that person considers that the law or some other legal act violates the generally accepted rights and liberties of people. At the same time, the sphere of competence was increased so much that even foreigners could apply to the court, and this actually took place even by stateless persons. And so, the next question. Have there been any questions which had been finally decided in a conflict? Today, the rapidly changing political and economic conditions, both inside the state and in a global state, require effective measures to protect the rights and freedoms of every man and citizen, as well as maintain the rule of law. In such circumstances, the decisions of constitution which have an impact on all legislative regulations and contribute to the resolution of dissonant situations have arisen in the process of applying certain legal positions on the subject require extreme importance. The decisions of the Constitutional Court, which establish the process of constitutional proceedings, the shortcomings of legal regulations, and determine possible ways to eliminate them, at the same time can also entail legal consequences due to the termination of the norm of an unconstitutional interpretation. In this regard, the decisions of the Constitutional Court must a priori have such characteristics as finality, general obligation, and non-appealability. The special significance of decisions taken by Constitutional Court, as noted earlier, lies in the establishment of unconstitutionality of laws and other acts which require strict execution by the relevant state bodies of the decision expressed in bringing the normative rule to act in accordance with the conformity with the Constitution. At the same time, either non-execution or improper execution of the decisions, the binding nature of which has a constitutional legal basis, not only harms the interests of justice, but also undermines citizens' trust in the judicial system and, in general, the state, obliged to recognize and protect the rights of freedoms of each person and citizen, which is one of the most important prerequisites for maintaining social peace. Based on the responses of the participating states, in the overwhelming majority of countries, the decisions of the constitutional courts are final and generally binding, not giving rise to conflicts. At the same time, there's an obvious problems of the execution of the decisions of constitutional courts, which may be mediated by a variety of factors. In particular, such problems may be associated with the lack of clearly regulated mechanisms for the execution of decisions, or difficulties in the implementation associated with needs for the financial funding from state budget or other features of state regulation. In the course of reading the responses of the participating states, I drew attention to the experience of the Constitutional Court of Slovakia in its decision of the 24th of October 2012. Thus, in 2012, the Constitutional Court interpreted Article 150 of the Constitution of Slovakia, which provided that the President of the Republic appoints the Prosecutor General based on the proposal of the National Council, ruling that the President's role was not merely ceremonial, and the President may request a different candidate if there were legitimate doubts regarding a candidate which might threaten the authority of the office to which he or she were appointed. Later, in June 2014, a new president took office, and shortly therefore, the terms of the office of 3 constitutional courts expired. The Parliament had proposed 6 candidates for the 3 vacant positions, as the Constitution required. The President considered the above interpretation to be fully applicable to the nomination of constitutional judges, and only appointed 1 judge to the Constitutional Court. However, his request for new candidates for 2 remaining vacancies were refused. The Parliament held that the interpretation concerning the Prosecutor General was not applicable to the case at hand, and the President had to choose from amongst those 6 candidates, that is 3 of them, to become constitutional judges and not just 1. The candidates which the President refused all filed constitutional complaints, and the Constitutional Court found a violation of the Constitution and constitutional rights to access to public office. However, the President of Slovakia did not recognize the decision of the Constitutional Court as being binding, and requested the matter from the Venice Commission. The Commission stressed that the Constitutional Court is the final arbiter of constitutional questions in Slovakia, and the ruling should nonetheless be respected, since it represented the final opinion of a majority of the Constitutional Court in Bangkok. For this reason, the Commission concluded that there could be no doubts that the 2012 interpretation referring to the Prosecutor General was not applicable to the appointment procedure for constitutional judges, and advised the President to respect it. Later, the President eventually appointed 3 new judges, as he was required to do. In this example, we have confirmed the significance of the decisions of the Constitution and the importance of their strict and proper executions.
Органа конституционного контроля, осуществляющего надзор за соответствием Конституции каждого закона или иного нормативного правового.
And so, what I want to say here, that finally, the final questions and the non-appealability did not bring about any arguments. But the problem is in the implementation of decisions. And this question is based on the responses to the questionnaire that was sent out to nations participants, and also based on the practice of my country. I can say that the question is in the correct and comprehensive and timely execution of carrying out of the bodies of the constitutional control. Now, has the role of your court in settling disputes and thus contributing to peace when has been challenged by other state powers or the media, for instance? This is one of the questions that was raised, to which my colleagues responded. There is no doubt that the process of drafting a law and the adoption of further implementation are complex processes and which are fraught with the emergence of uncertainty in the context of legal norms and their unambiguous understanding and implication. At the same time, it is obvious that the adoption of ideal laws is impossible, since due to the constantly evolving dynamic social relations. In this regard, it's also has to do with the principle of forming the creation of these law-making bodies, which are basically political processes. In this regard, the role of the constitutional courts in eliminating contradictions in laws and other normative aspects and bringing them into full complexity is being strengthened. As we can see from the responses, the role of the Constitutional Court is not challenged by other state bodies. And this is facilitated by special status of the body of the constitutional control and the juries, whose acts are final and not subject to appeal. In addition, constitutional courts in general practice carry out their activities based on the principle of independence, which consists in their subordination only to the Constitution and the law. The principle implies the prevention of intervention in the activities of the body of the constitutional control, which may entail liability provided for by the law. At the same time, the very specifics of the activities of the constitutional courts and other courts can be perceived negatively by one of the parties participating in the judicial process. And this is natural. Challenging the role of the constitutional court by mass media is quite acceptable in view of the right to freedom of expression, freedom of speech, and of the press. And another issue is the competence of certain assessments, since the constitutional control bodies, when considering a case, carry out enormous work in a comprehensive study of the issues from all angles and from positions in order to make the appropriate decision. Question: has your court has been confronted with a positive or rather critical attitude in society and in the media as far as the trust in reconciliation of the court and of the judiciary in general is concerned? In any democratic state, the relationship between public authorities and the media is exclusively controlled by the Constitution and the laws, which on the one hand guarantee freedom of the press, their right to receive information as well as dissemination, and on the other hand, provide access to information under the jurisdiction of public authorities. The role of the media is not only that they carry out the function of informing society, but also that they act as a means of controlling society over the activities of the authorities. Therefore, in democratic countries, the media are free and operate in accordance with the law, and censorship, of course, is not allowed at all. The general world trend in relation to activities of constitutional bodies is, shall we say, positive rather than negative. Despite the presence of criticism of any part of the population of the country, the decisions of the constitutional courts are binding, and the non-execution or improper execution, which entails liability, provided for by the law. We therefore have to bear in mind the fact, bearing in mind the responses to participants, that most of the criticism is directed at the constitutional decisions, which therefore become questions to be decided by the constitutional courts. But bearing in mind, society, in this case, carries out a positive role in the operation of constitutional control. If we take the Constitutional Court of the Kyrgyz Republic example, then, as in any democracy, its decisions cause reactions in society, both positive and negative. Such an assessment on the part of society is natural, since it's a kind of feedback from the society to the actions of the highest body of the judiciary exercising constitutional court. A similar position is in Finland, Burkina Faso, Canada, Cambodia, several North Macedonia, and Portugal. In many states, the decisions of the Constitutional Court have received a rather positive reaction from civil society and from the media. For example, the reaction of the Albanian media and society to the Constitutional Court of Albania of 2010, in accordance with this agreement between Albania and Greece on the delimitation of their respective territories, of the continental shelf, and other maritime areas belonging to them under the law of the sea, was considered to be incompatible with the Constitution, and this was positive. The decisions of the international courts of a number of countries such as Algeria, Andorra, and Angola, society and the media are quite positive and trusting. Undoubtedly, the implementation of the Constitutional Court that exclude any external influence create fertile ground for achieving the tasks and goals set for the court, which at the same time helps to increase the level of public confidence, including the media, in the activity of state bodies. Thus, in Austria, Denmark, Czechia, Germany, Korea, Switzerland, Thailand, and a number of other countries, according to the replies, the attitude towards the Constitutional Court is very positive. This is mainly explained because Constitutional Justice retain good relations with the media. And only a decision that is consistent with the Constitution can be accepted by the Constitution as correct, even if it does not lead to reconciliation, but on the contrary, to hostility or deepening antagonism. The Czech response is admirable because there's never been a case where the Constitutional Court has been accused of not promoting reconciliation with its decisions and has never been praised for promoting reconciliation. Often, constitutional control bodies, due to the volatility of the political situation in the country, are forced to work in various pre-conflict and post-conflict situations, in which even a positive voice from society helps protect them against the attacks of other authorities. In this respect, the number of appeals by the Constitutional Court of Bosnia and Herzegovina, thus in 2018, the Constitutional Court received 7,767 referrals, which is a clear indication of the increased trust in the work. Unfortunately, the bodies of constitutional justice, as well as all other bodies, are not protected from all kinds of unjustified attacks, including from the media, which in turn directly affects the level of public trust, especially in the direction of its decline. At the same time, that is, they are reduced. At the same time, the bodies of constitutional court show tolerance for criticism, since criticism stems from the essence of democratic regimes, in which freedom of expression is important, and from which the activities of relevant courts are not excluded. And here I would like to underline that this tolerance, which the constitutional courts demonstrate, this is so clearly observed as distinct from other authorities and other bodies of the state. Despite the underlying phenomena that occur during the implementation of constitutional legal proceedings and after its completion, public trust in constitutional justice is constantly growing. And their activities are generally positive. And I came to this conclusion based on reading the responses for the participants. And their activities are generally positively assessed by civil society, which is confirmed by a growing number of referrals to the Constitutional Court. And in conclusion, I would like to take the opportunity to once again to return to the question that we must not underestimate the role of Constitutional Court in guaranteeing social peace and in guaranteeing justice. And if we were to absolutely guarantee the rule of law in every country, then I believe that by this itself, this will directly oppose intergovernment conflicts. If we could have social peace in every country, then I think this will never rise to the level of interstate conflicts. I would like to take the opportunity once again to express my gratitude to the organizers of the Congress, represented by the Constitutional Court of the Republic of Indonesia, and the organization of such a global forum. Thank you very much for your attention.
Yeah, comprehensive coverage. Thank you very much. And now we turn the floor to our discussant. Unfortunately, we have a very short time limitation because we have to leave this room at 4 o'clock, at 4:30. So, Your Honor, you have the floor.
Thank you very much, Mr. Chairman. I'd like to say hello to all the members of the Constitutional Court of Indonesia, all the participants present here at this conference. First, I'd like to express our deepest gratitude to the Constitutional Court of Indonesia and the Secretariat of the World Conference on Constitutional Justice for the very warm welcome extended to us and the organization put together for this conference. In connection with this Congress, we must point out that as far as the Republic of Angola goes, it has a history of post-independence armed conflicts, and therefore peace is the very first term that is mentioned up front in the first article of the Constitution. The definition of peace is, however, not just maintaining peace or just the absence of war, which fortunately we haven't been facing since the last 2 decades, but peace means actually that what we are debating here in this conference as a fair social peace. So in this article of our Constitution and in other articles mentioned, especially in response to the questionnaire, the term peace, as I mentioned, does not have the meaning of absence of war. It means a lot more than that. It means social peace or achieving social peace. The topic that we are discussing here, and which was very clearly presented by Chief Justice Emil Oskonbarth, I hope I've said the name correctly, is about the limitation of the role of constitutional courts in maintaining peace. And here we are discussing the limits imposed on the remits of most of the constitutional courts, which are called upon to regulate and establish peace in societies, and to this extent to contribute to the achieving social peace overall. Now, this is what most of the constitutional courts have several attributes in their remit, but in Angola, we are also called upon to oversee the constitutionality of norms and even judicial and administrative decisions, as well as the legality of electoral processes. That means in Angola, the Constitutional Court is the body which has the remit to verify the electoral processes and to validate those elections. It's obvious that the protection of human rights is a precondition to any conflict resolution and guaranteeing social peace. And observing these constitutional principles in its decisions should contribute overall to social peace and This is possible only if the people have confidence and trust in the law and in the courts. Now, President Emil Oskonbaev raised some very critical issues based on the Angolan experience. I'd like to express a very few thoughts in response to the questionnaire. In his presentation, the keynote speaker talked about three fundamental aspects, which are, first, the importance of why interested parties can bring their cases before a court. The second one is the relationship between the constitutional tribunals or courts and other organs of the state. That is a type of relationship that exists between constitutional courts with each of the sovereign organs of the state. The third one is about the fundamental role of the media and the constitutional courts. That is to say, to what extent the media believe that it's worth mentioning what is being conducted in the constitutional courts, what its decisions are, how it impacts society. And so you have the private media and you have public media. So how these two can play a role here. Now, they do have a vital influence on the role of the constitutional courts in maintaining peace. Based on the responses from the members who have responded to the questionnaire, it's clear that except in some rare cases, it is important to have third parties bring a case before the courts. And this only on an exceptional basis that these courts have the legal right to take up a case suo motu, that is, of its own initiative. And this is what happened in the case of the Serbian Constitutional Court. Most of the constitutional courts are limited in their actions in that they do not have a suo motu possibility, and it all depends on third parties. They can only deal with the constitutionality of the matters brought before them by third parties. Besides that, we have, for instance, the Office of the President of the Republic, the Attorney General's Office, parliamentarians, and especially in the case of the Republic of Angola, citizens, that is, any private citizen, can appeal judicial decisions and administrative decisions that run counter to their rights, freedoms, and guarantees provided for in the Constitution. But they can do this only when they have exhausted all other avenues in the lower courts and other possible avenues available to them. That is to say that the citizen has to go step by step, and only when a citizen has exhausted all those possibilities, that is the first instance, second instance, etc., only when all the issues raised have been exhausted through the system, only then can they appeal to the Constitutional Court. And the only exception here is in the case of electoral processes. As I said earlier on, in our case, that is in Angola, the Constitutional Court can actually intervene suo motu on the legality and validity of the elections. And in such situations, any citizen can challenge the candidature of a political party or a coalition of political parties before the Constitutional Court. That is, if one political party or a coalition of political parties, if any citizen can go to the Constitutional Court and challenge the viability of this candidature. At any rate, the Constitutional Court of Angola cannot take up any case suo motu, that is, of its own initiative. There has to be an applicant who brings a matter before the court. So the Constitutional Court of Angola and most constitutional courts play the role of the custodian of these bodies, and they usually work on the fundamental principles provided for in the various constitutions of the countries. Besides not being able to preempt any conflict, and besides the constitutional courts not being able to avoid conflicts by taking any action, they do play a role of keeping the peace, especially when competent bodies bring a matter before them. Dear colleagues and participants, the second and third aspects highlighted by the speaker cover the second, third, and fourth issues of this topic under consideration, which has to do with the non-compliance of the decisions of the constitutional courts and its role being challenged by the various organs, that is the executive and the legislature, and the media. And though its role is to maintain peace, it has to see to what extent it can inspire confidence and trust in the citizens, in the rule of law, and the institutions of the state. In actual fact, constitutional courts are the last instance where matters of constitutionality are finalized, and their decisions are final and binding, especially in Angola. And this is binding for all public and private bodies where these decisions prevail over all others. As it was said this morning, the issue between the hierarchy of jurisdiction of various tribunals or courts in various states, between the Supreme Court and the Constitutional Court, which court has precedence over the decisions of the other. I could say that in Angola, despite the Constitutional Court not being part of the hierarchy of the common courts, the decisions of the Supreme Court are reviewed or can be reviewed by the Constitutional Court, and the decisions of the Constitutional Court have no further appeal. It's also been said in some concrete cases that the decisions have been enforced with resistance, and the constitutional courts have had difficulty with seeing their decisions implemented. And most of the members who responded to the questionnaire had this complaint. Now, what impact the decisions or the compliance or non-compliance with the decisions of the constitutional courts have on society? It's quite alarming when you see that the constitutional court's decisions do not have primacy in reality. And the constitutional courts, which are the custodian of safeguarding the constitutionality of norms and decisions by courts, the trust of the citizens in the courts, in the legal system, in the state, or in the rule of law is very important, because if there is a conflict, as our previous speaker said, we need to be able to inspire trust and confidence by the citizens in the system in order to guarantee that the system works. Now, as far as the constitutional courts go, most of them have their decisions come under the scrutiny of the media and civil society at large, and at times these are also highly criticized. These are criticisms which are very profound, and this is reflected in our reality on a day-to-day basis, and this is where you have the media in the private sector and the public media, which have a major difference in the way they see things as far as the very nature of constitutional process, which presupposes the existence of various parties, concerned parties, which may be opposing each other, could have a decision which is poorly received by one of the parties. And this could be expressed in public in a rather difficult way for the courts. And it's quite common that public declarations are made complaining against the Constitutional Court, its decisions, and this sometimes the Constitutional Courts have been said to have superseded the legislative and executive powers in a democracy, and especially from the point of view of the principle of separation of powers, this is seen very negatively. The media often question the decisions made by the constitutional courts, and given the very strong arguments put forward by the courts to support their decisions. But sometimes the decisions are misunderstood by the media, and therefore it is important to make public clarifications in order to protect the image of the constitutional courts and ensure that the citizens continue to trust the constitutional courts. By way of conclusion, despite the number or most of the constitutional tribunals not having the ability to take up a matter suo motu, they do contribute to social justice through the decisions they make, to the rulings they hand down, and through the laws which are enforceable. They continue to safeguard the fundamental principles of the rule of law and human rights. Thank you very much indeed.
Comprehensive coverage. Apparently, time has hit us. We cannot stay in this room any longer for logistical reasons, so we'll have to come to the conclusion of this session right now. This is very unfortunate. Nonetheless, we'll be having the opportunity, so long as we are here, to communicate and exchange our views. And those who unfortunately have asked for the opportunity to pose question could really, come to us and speak one-to-one throughout our stay for the coming couple of days. So I thank you, and I thank the Constitutional Court of Indonesia once again for the wonderful organization and warm hospitality. I thank Venice Commission, I thank the General Secretariat of the World Conference, and I thank you all for being here. Thank you and all the best.
Right, thank you, the Excellencies. Thank you as well, His Excellency Adel Omar Sharif, for moderating our last discussion on today's event. Ladies and gentlemen, we have reached the end of our event, the 5th Congress of the World Conference on Constitutional Justice with theme Constitutional Justice and Peace. And I would like to inform you all that we are strongly expect you to stay in this area in BNDCC Nusa Dua, Bali, as the opening ceremony will be started at 6:15 p.m. on local time in this room, in the same room. And also we would like to inform you that the gala dinner will be started right after the opening ceremony. So please enjoy the rest of your afternoon and also enjoy your coffee break, which you can take your coffee break in the foyer area in this building as well. Thank you very much. Good afternoon. Bye-bye.